Yes, good morning, Your Honors. Good morning, Your Honors. My name is Lisa Ann Dodds, and I'm here today on behalf of the appellants, Ms. Kirsten Wolf and Mr. James Cundiff. I would like to respectfully request 5 minutes for rebuttal.
Sure.
Thank you. This is a case that stems from an unreasoned denial of appellant's requested relief. The relief.
Ms. Dodds,
Yes,
before you jump into the merits of your argument, can
Yes,
you walk me through why we have jurisdiction over this appeal? Because I'm not really sure what happened. I know there was a motion to dismiss filed by Mr. McIver. You never responded, and yet somehow it got summarily denied, I believe, in our court. So I'm just trying to figure out. I want to give you a chance to actually give an answer as to why we have jurisdiction.
Your Honor, you have jurisdiction because the trial court denied the requested relief, and I believe it was because the judgment was void, therefore kicking it up to you guys. I'm unsure what the motion to dismiss, I haven't looked at it in a while, but the appellee's motion to dismiss, I believe, was the same argument that they've been making since the trial court, and they also made it in the their answer brief. So I believe that's possibly why it was denied by the appellate court without hearing. That's the only thing that I can assume from it. So as to why the District Court of Appeal went ahead and denied their motion to dismiss, I'm unsure. All I know is that it was denied and you guys have jurisdiction because of it.
Okay, because you're appealing the denial of the third 1.540 motion, correct?
Yes, Your Honor.
Okay, go ahead. Thank you.
Yes, Your Honor. No worries. So then I'll go ahead and backtrack. We are seeking redress of a denial of the motion for relief. So the relief requested was we wanted to go ahead and correct what had happened in the summary judgment hearing. So being that the judgment was void due to what occurred at the summary judgment hearing, this goes into the due process argument. So this court has said specifically that due process is not just notice and an opportunity to be heard, but it's notice and a meaningful opportunity to be heard, which means for them, the appellants, to go ahead and present questions of law, to present their own evidence, to direct and indirectly cross-examine witnesses, and none of this was done. So why was none of this done? Well, there was another due process violation that occurred at the summary judgment hearing. My clients never got an opportunity to be heard. Their affirmative defenses were never addressed, and the affidavit filed by my clients, the appellants, was entirely thrown out. Well, what would lead a court to go ahead and strike everything that appellants had in defense? Well, number one, it was predicated on the idea of judicial estoppel. So they're saying that Ms. Wolf, one of my clients, and Mr. Cundiff were not allowed to go ahead and use the affidavit because Ms. Wolf had filed bankruptcy allegedly 4 years earlier. Well, the problem with that is the standard that was cited by the appellees for the res judicata argument. I'm sorry, the estoppel argument. My apologies. The estoppel argument was based on the bankruptcy law, where it says specifically that we're not supposed to use the bankruptcy law. We're supposed to use the Florida rule. That's the Haddon v. State Farm case. So when we use
that, just sounds like you're saying that the trial court made a legal error. How does that qualify for relief?
Yes, Your Honor. Well, there were multiple errors throughout the process. That one built on the next one, built on the next one, which led to a complete denial of due process, which is something that we thought redress for. So the denial of due process, first, it was kicking out everything of Ms. Wolf, not being able to use it at summary judgment. But Ms. Wolf's affidavit, which was based on her knowledge and belief, was also not able to be used for her co-defendant, her husband. So the court on its own, without making a finding as to Mr. Cundiff's affirmative defenses, entirely ignored them. So the improper denial of appellant Wolf's affirmative defenses and the throwing out of her affidavit in opposition and not letting her use it for the co-defendant, even though it was based on knowledge and belief, that was the first set of denial of due process. So following that, being that my clients were effectively silenced, they were there, they had notice, by and through me, they had notice. However, there was no opportunity to be heard. We were essentially silenced when we couldn't use any of that. Now we go to the next step. When you're essentially silenced and you're not getting the due process that you should under the law, then it says that there's a very good chance that that's definitely going to be a void judgment. If anything, it's a judgment that was procured by way of misrepresentation and fraud, which was set forth very specifically in our first motion, the affidavits that accompanied the first motion, as well as the amended motion, which contained exhibits A through N, which were mostly the appellee's exhibits. So we filed the motion to go ahead and vacate on the grounds of fraud and misrepresentation, excusable neglect. So why the fraud issue? Well, the fraud issue is because the appellees presented evidence in the hearing that was neither verified, certified, and it was entirely relied on. So if those things are going to go ahead and be used as evidence to go ahead and prove their case, then my client should have been allowed to use the evidence and argument to go ahead and present their case.
And you knew that at the time of trial, though, correct?
All we had was a summary judgment hearing, and I did not know that my client's affidavits and affirmative defenses were going to be entirely struck at that point. The appellees had filed a request for judicial notice and a request for judicial estoppel that were both based or predicated on an uncertified one-page document attached to the complaint alleging that Ms. Wolf had filed bankruptcy 4 years prior. Well, the problem with that one is when I looked at the motion on its face, I was prepared to go ahead and argue, well, this is not the correct standard that applies. This is the bankruptcy standard, and there was no specific case law. So as we know from the Haddon State Farm case, in order to go ahead and be judicially estopped due to a bankruptcy, it's a different rule. We must have exclusivity of the parties. We must have a same question and issue. The appellees must have changed their position in reliance of this estopped issue, which none of those are present. The appellees are the fourth individual bank in a chain of assignments that began way back with the bankruptcy of Washington Mutual. So,
and I apologize for saying
Yes.
trial, but by the time the final judgment was entered, you knew all of this, correct?
I did not know that my clients were not going to be able to utilize their affirmative defenses and their affidavits to overcome summary judgment. So the issues that we have are things that could have been taken care of at trial. But being that my clients are deprived of their due process rights to have a trial, and is predicated upon their inability to utilize any of their affirmative defenses or affidavits, and that decision was made seconds before the summary judgment motion started.
Well,
So-
I guess what I'm trying to get at is you
Yes,
didn't
ma'am.
appeal, did you? You didn't appeal from the final judgment?
No, we did not appeal from the final judgment rendered at summary judgment because we didn't have anything to appeal. So the final order following the final hearing at summary judgment, it set out specific facts. It failed to set out any specific facts upon which the judgment could have been appealed. Of course, it was a blanket boilerplate one, but where there are typically findings of fact, such as the appellee's ability to reestablish the lost note, none of that was included. And being that my clients were not able to assert any counter argument to the summary judgment, that constitutes a violation of due process because they never had a meaningful opportunity to have their arguments heard. So when they simultaneously strike the utilization of the affidavit as well as the affirmative defenses of both parties, there still should be the obligation on the appellees to go ahead and prove that there's no material issues. So when there's no material issues, fine, summary judgment works. But if you looked at the presentation of the information that my clients had submitted, which would have been enough to overcome summary judgment, However, it was not viewed at all. So then we went ahead, and that's why we filed the motion to vacate, because if it's void or it's based on misrepresentation or fraud, then we have to say that it's void. So what kind of fraud are we addressing? We have to go back and we have to look at the actual judgment. There are 101 pages that were noted as a notice of filing prior to the summary judgment hearing. And these documents in and of themselves to have 101 pages, we know that almost speaks to the fact that there are issues that are material in dispute. So none of the, actually 3 of the exhibits that are attached to the notice of filing in support of summary judgment, those are the only ones that were attached to the complaint. So in order to go ahead and specifically address the allegations of the complaint, we needed to have all the evidence or all of the information that they were going to go ahead and base their argument on. We did not get that until beforehand. So as we're looking at this summary judgment information that was provided to us by the appellees, we noticed multiple inconsistencies, which are outlined in Ms. Wolf's affidavit, which she had firsthand knowledge of and would be ready to testify to in a trial. The inconsistencies included things like the acquisitions department of US Bank stating that they did a request for the note and they had the note. That's what their documents say. However, the complaint stated that they lost the note. Furthermore, Ms. Wolf was laid out specifically in her affidavit that the note, as it was filed by US Bank, that was nothing more than a robo-stamped one that did not match the one that was given to her by NationStar, which is the third lender. So also defective, as noted in the affidavit, is the assignment between NationStar and US Bank. The individual, Nicole Baldwin, who notarized the document, she's not a notary. This is information that we included. The individual who signed off as vice president on this assignment is not even employed. So these are all things that we presented. However, our ability to go ahead and discuss those was taken away from us. Hence why the motion to vacate was important, because it was a void judgment. How can we go ahead and get a judgment against us when we weren't even able to speak? So if we had an opportunity to speak, these are all things that would be raised. So being that we thought the judgment was void, we had to go ahead and state why it was void. And we asked the court for redress. Unfortunately, the court on the first occasion, before I had even received the judgment, denied it with no explanation. The amended motion to vacate, which was filed before the first motion to vacate was even, the decision on that was even received. The second one, the amended one, set forth 20 some odd exhibits that laid out specifically the fraud upon which the summary judgment evidence or documents had been attained or used. These documents were used in a completely contrary capacity to what it stated in the complaint. So we have statements in the complaint that are absolutely contradicted by the evidence that they purported to use. Furthermore, all of the evidence that they presented at the summary judgment hearing was none of which was certified, none of which was sworn to. So these are all things that we tried to bring up. However, the second motion to vacate, the amended motion to vacate was denied without any explanation, just the word denied. So it can only be assumed that the reason that the amended motion to vacate was denied was based upon the appellee's response in opposition. Appellee's response in opposition stated that we, the appellants, were unable to go ahead and ask for a relief under the motion to vacate, as the court was stopped, didn't have jurisdiction, and was not able to hear it. However, there's no reason why a 1.540 cannot in and of itself be subject to the same rule. And it was only an amended one which elaborated on the prior facts. And furthermore, it was facts and a order that did not come from an adjudication on the merits. So once there was the denial of the amended motion to vacate, of course, with no other rationale and without a hearing, despite what we believe to be a colorable entitlement to relief, as we had all of the correct claims and the meritorious defense. So with that being said, I went ahead and I filed a second motion to vacate, predicated upon the idea that the first motion to vacate, including the amended portion, it was never adjudicated on the merits. And in order to be barred from bringing up that issue again under res judicata, there has to be an adjudication. So this
Besides, you're at your 5-minute mark, so proceed as you wish.
We'll go ahead and save the rest for rebuttal.
Okay, that's fine. Mr. McIver.
Good morning, Your Honors. My name is Richard McKeever. I am attorney for U.S. Bank, the appellee. May it please the court. The narrow scope of this appeal relates to the two orders that were filed by the judge in denying Mr. Cundiff's motions, the third motion to vacate and his post-judgment motion to amend his answers and affirmative defenses. Ms. Wolf, although she is a nominal party in this appeal, was not a party to either of those two motions. The standard of review of these two motions is abuse of the trial court's broad discretion. Now, Mr. Cundiff's initial brief and indeed the arguments today were devoted pretty much to the final judgment, which this court does not have jurisdiction to hear. The time for appeal passed and no appeal was filed. It became a final judgment. 2 months later, the first motion to vacate the final judgment was filed in June and was denied several days later. An order was entered by the court. The second motion was filed and denied. The third motion was denied and filed, all based on the same grounds. And as our brief states that the 1.540 is not a substitute for an appeal. The court's inquiry is limited to whether the court abused its discretion to the limited factors in the motion. The Troiano case says you can't bring up new issues in the motion to vacate that weren't before the court at the time of the hearing. The rule does not allow new claims. The Fenian versus Love case that was cited in our brief quotes the Viking General versus Diversified Mortgage case out of this court. The purpose and intent of Rule 1.540 is not to reopen lawsuits to allege new claims. The court should disregard any arguments made in the brief and today which question the validity of the final judgment as no appeal was filed. In addition, the rule is not a substitute for rehearing or new trial under 1.530. Mr. Cundiff cannot use the rule as a second, third, or fourth chance at the proof that he failed to produce at the hearing. Now, as a review of the record shows that Mr. Cundiff's answer and affirmative defenses alleged some affirmative defenses that were totally unrelated to mortgage foreclosure. And Ms. Wolf's affirmative defenses were stricken due to the court's ruling in the 11th Circuit's ruling in the In Re Faya case, where a party surrenders a property in bankruptcy. They're no longer allowed to defend the foreclosure, and her answer was appropriately stricken at the hearing. But we're not here on that today. That order was not appealed. Mr. Cundiff was not entitled to a hearing on any of his motions because the motions did not state a colorable claim for relief under the rule. There were conclusory allegations of fraud in the mortgage industry, and they were not specific to this case, specific enough. They nibbled at the edges of fraud, as some of the courts have talked about. They were not sufficient. And because Mr. Cundiff's answer and affirmative defenses did not even raise the issue of fraud, it was appropriate for the court to deny the motion without a hearing. This court, as recent as last Friday, entered an opinion on the Deerbrook South versus Battles case in the second DCA case of 19-1988. It said that issues not raised in the pleadings are waived. You can't bring them even at the summary judgment hearing. You can't raise it for the first time at the summary judgment hearing. And what Mr. Cundiff is trying to do is raise it after judgment has been entered. Finally, the motion to vacate is barred by res judicata, as the court has, the trial court previously rejected the first two motions and entered orders denying them. Under the Purcell and Virgo cases, it's error for the court to entertain motions that could or could have raised issues in the first motion but didn't. So even if there were new issues that were raised in the third motion, it's inappropriate for the court to give the defendant appellant a fourth bite at the apple. As to the post-judgment motion to amend the final, to amend the answer and affirmative defenses, the cases relied upon by the appellant are distinguishable. Typically, those cases relate to situations where there was a default judgment entered, excusable neglect was shown, meritorious defense. In this case, we had defendant was represented by counsel. She was in the case and then out of the case and back in the case. 7 months before the summary judgment hearing, she had an opportunity to amend. At that time, the affirmative defenses, if she thought they were insufficient. The court's case, this court's case in the Triax decision says that it's inappropriate to allow an amendment of the pleadings post-judgment unless the issues were tried by the consent of the parties. And clearly that wasn't the case. The issues were not tried by consent. For all of these reasons, we ask that the court affirm the two orders on appeal and deny the appeal as to the appellants. Thank you.
Okay, thank you very much. Ms. Dodds, are you there? There you are. Okay.
Yes. So to go ahead and go back to what the appellee had cited, in the Virgo v. National City Mortgage case is distinguishable not only because it raised issues that were, it raised issues that were not decided in a prior proceeding. One more time, let me try that. The Virgo case is distinguishable because in that case, the issues had been decided in a proceeding that was prior. We did not get an opportunity to have a hearing or a decision prior to the entry of a final judgment. So being that we did not get to go ahead and have these arguments, how could they have been raised by a party? So it kind of counteracts itself on that note. Another case that I found of interest is that the Specialty Souls Baxter Gypsum case, May 22nd of this year. So it talks about the standard for an appeal based on a void judgment as being de novo. It's our argument that the judgment is void due to the fact that they were denied due process. So even if at that summary judgment hearing, the affidavit upon which we relied that was struck, it's still allowed to be used for the co-defendant because it was based on knowledge and belief of an individual who is able to testify. So if Mr. Cundiff was able to use co-defendant's affidavit in opposition, we would have been able to overcome summary judgment. Furthermore, we do not believe that they had even proved their side. So we also do not believe that our argument or the second motion to vacate upon which we're appealing, it's not successive and it's not barred by res judicata. That's the state DOTV Bailey case. We believe that it is analogous because of course it again stems from a summary judgment, and that judgment then was void due to the fact that that issue was never addressed. It was addressed and it was improper for summary judgment to be issued because it was void. So we're standing on the same thing here, which is why we had to examine the underlying judgment for the voidness, which is why we had to bring it up. In that case, they also did not do a direct appeal, but they sought a determination of issues that were not previously determined, which is the same thing in our case. Furthermore, the fact that both parties' questions must be the same in reliance of one another, that's the Bloomberg v. USAA case. And that is the issue that went ahead and has stopped Ms. Wolf from even being able to participate. So a named defendant who is having their home taken for them is not given any reason or an opportunity to be heard. So what we're talking about is US Bank being able to go ahead and prevail on a judgment by a defect. It's the opposite of what all of the DCAs across the state have been apprehensive to do. Except in this case, it's the other way around. Of course, this state has questioned the idea of giving a free house to appellants based on a technicality like standing. However, this is actually the inverse. This is where the appellants are now having their home taken and essentially given a free house to the bank. They're given a free house to the bank because they never got an opportunity to defend their action. If they had an opportunity, then we would be able to present information. But due process is such an important element because at summary judgment, we're deciding whether or not there are issues that should proceed to trial. And if those issues are not allowed to proceed to trial because they are of no merit or no consequence, then that makes sense. Then we're allowed to cut due process off there and stop. However, that was never done. So my clients were deprived further due process by not being able to have an actual hearing or a trial on the merits where they would be afforded an opportunity to present this information. So all of the documents that we questioned, we have good reason to question, and these are things that should have been presented at a trial. So if we are deprived of that trial, then we're deprived of due process, and it's all predicated upon the denial of my client's rights to assert themselves at the summary judgment hearing. So we respectfully request that this court reverse the lower court's decision and remand with instructions to involuntarily dismiss or allow the case to proceed on its merits.
Thank you, Ms. Dodds. Thank you both very much.
Thank you, Your Honor.
Thank you very much, Your Honors.